Hello, everybody. Today we're going to do a walkthrough, a full constitutional law analysis, the way the California bar expects you to do it, methodically, hierarchically, and a little more formally than feels necessary. So, the theme of today is that we're going to be relentlessly constitutional. We're going to state rules even when the short answer feels obvious, because that's how bar graders know you know what you're doing. So, our focus today is going to be the First Amendment, but we'll begin where every constitutional analysis begins with those threshold issues. Now, this lecture is built around a single hypothetical. Nothing today is abstract. So, let me give you the hypothetical. The state of California, or the state, right? The State Department of Education, the DOE, runs a program to help schools facing budget shortfalls. Under the program, DOE directly provides secular textbooks and instructional materials to qualifying schools. St. John's High School, also known as St. John's, is a private religious high school and participates in the program. Teacher, a longtime teacher at St. John's, lives with her boyfriend, the father of her child, and is not married. Her original job application asked about marital status. She either left it ambiguous or answered in a way the school now calls misleading. After teacher publicly criticizes St. John's religious control over staff, the school terminates her, stating that her living arrangements violate religious principles. The teacher begins daily protests in front of St. John's with signs criticizing the school. The school threatens to call police for trespass, and they seek advice about getting an injunction to stop the protest. So the teacher consults an attorney, and there's three issues. One, whether providing educational materials to high school constitutes an impermissible endorsement of religion. Two, whether her termination violates the free exercise clause. And three, whether she may constitutionally protest daily in front of the school. We have three key players. We have the State Department of Education. They're a private religious high school, and a longtime teacher who has been terminated and is now protesting. So, as you read this, you should already be flagging constitutional tension points, right? State aid to religion, employment decisions based on religious principles, the protest activity, right? That may trigger First Amendment protections. So, this is our fact pattern, and we're going to use this as our real life example. So, keep this fact pattern in mind because we're going to keep coming back to it. Now, our constitutional analysis always follows a strict order of operations, right? Remember, think PEMDAS, right? But it's PEMDAS for con law, right? So it's not, please excuse my dear Aunt Sally. Whatever you do, do not jump straight into your individual rights, even when that feels like that's the obvious point to start or where that's the obvious action is, right? You need to start with judicial review. Then you move into government power and then into individual rights and then finally into remedies. On the bar, even when threshold issues seem very easy, you still have to state them and go through the analysis. That signals competence and it earns you points. Don't miss out on easy points. So remember, we always want to start with judicial review. Then we want to move into government power, then individual rights, and then into remedies. And we want to do it methodically so we don't lose on points. Now, this checklist is your anchor, right? This is our top down. Every constitutional law essay, no matter how complex the facts or how narrow the issue, can be organized using three categories, right? Judicial review, exercise of power, and individual rights. It's not just a memory aid, you guys. It is a signal to the grader. When you follow this structure, you're showing the grader that you understand constitutional law as a system, right? Not as a collection of disconnected doctrines, but as a system. So today we're going to move more relatively quickly through judicial review and government power. Not because they're unimportant, but because you already know them and we've already covered them. This is a review. You've seen standing, rightness, mootness, and state action before. What we're doing is practicing how to dispose of those issues efficiently and correctly, the way a high scoring bar answer does. Our real work today is going to be in individual rights, and this is where most of your points will come from. And this is also where students tend to lose structure and where they tend to kind of lose the plot in an essay. Now, the temptation in a constitutional law essay is always to jump right into the speech or right into the religion because those are the more interesting issues, right? Because we know that they're going to be fun and that they're going to be something that we can debate. But the bar doesn't reward you for just jumping into the fire, right? The bar rewards you for orientation, for your top down, right? For ensuring that you understand that constitutional law is a system, not a collection of doctrines, right? So when you walk through the checklist every time, even if it's just briefly bringing it up and shooting it down, you're proving to the grader that you know exactly where you are in the analysis before you start running. You're saying to the grader, hey, 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 I know this court, right? I know the court can hear this case. I know who the actors are. I know which branch of constitutional law I'm in. And that matters. That matters a lot because graders, they're not going to guess what you know, right? They're inferring it from how you organize your answer. So a student who just starts with the checklist, right? They look deliberate, they look controlled, they look competent. But if you're a student who just jumps right into the First Amendment, then they're going to be like, this is rushed, even if their doctrine is right. So think of the checklist as your roadmap, right? You don't drive by flooring the gas pedal. I mean, I know my 16-year-old does, but we don't, right? You drive by checking where you are, where you're going, what rules apply on the road. And that's the structure that you want to use on the bar exam. Now, this slide shows you exactly how threshold issues should be handled on the bar. And I want to be very clear about something up front. These issues are not here because they're difficult. They're here because they're required. So on the California bar, you don't get credit for silently recognizing that an issue is satisfied. You get credit for showing the grader that you recognized it, that you stated the rule, that you applied that rule, and then you resolved it even when the answer feels obvious, right? So just be glad if it feels obvious. That means it was easy to issue spot. But if it's easy to issue spot, that doesn't mean you skimp on that top down analysis. So let's start with standing, right? Because standing asks whether the plaintiff has suffered a concrete constitutional injury that can be heard by the court. Right here in our hypothetical, the teacher lost her job, right? That's a textbook injury. In fact, it's concrete, it's personal, right? It's not speculative. The loss was caused by the school's conduct, and it is redressable by a court through damages or injunctive relief. The entire analysis should take one or two sentences on the bar. You don't need to overthink it, but you absolutely must state the rule and apply it. So saying teacher has standing, right, without stating the elements, that's not going to earn you full credit. The grader's looking for both of these things, right? Not just your conclusion. Once we address whether we have standing, then we get into ripeness. Ripeness asks whether the dispute is ready for judicial review or whether it's too speculative or too premature. In this case, the school is threatening to call the police and get an injunction. That means the teacher faces an imminent, right now, and concrete threat. She doesn't have to wait to be arrested or enjoined before bringing suit, right? Again, this is a quick analysis, but it's still an analysis. One sentence stating the rule, one sentence applying the facts, and then you move on. The bar rewards recognition of a threat of enforcement. They recognize that is enough. You don't wait for the harm to fully occur. Then we move on to mootness. Mootness asks whether the controversy remains live at every stage of litigation. And here, nothing's been resolved. The teacher's still fired. She's still protesting. The threat of enforcement is still present. And that means the case isn't moot. Even though this feels almost silly to say out loud, you still say it. On the bar, if you answer with silence, they take silence as ignorance. So when we were growing up and our parents say ignorance isn't a defense to the law, right? That's what we're talking about here. On the bar exam, silence looks like ignorance. So remember, mootness is one of those issues that students skip because the answer feels obvious, right? It seems obvious. There is still a live problem, right? Something is still happening. And if you don't answer this, even if it's one or two sentences, that's a mistake. One sentence disposing of mootness earns you easy points. Don't miss out on easy points. And now we get to state action. State action, this is the critical gatekeeper, right? This is one of the most important threshold concepts in constitutional law. The Constitution limits government conduct. It does not generally regulate private behavior, no matter how unfair or offensive that behavior may be, right? We don't care what your neighbor is doing. Your neighbor can say the worst things in the world, but if your neighbor is not a government actor, then he's not, beholden under the Constitution. So, in our hypothetical, St. John's, right? It's a private religious school. The fact that it receives secular textbooks from the state does not automatically transform it into a government actor, right? It doesn't automatically do that. And that means constitutional claims tied to the termination may fail before we even reach our discussion on individual rights. And this is where students often go wrong. They see a constitutional right and they immediately start applying tests. But if there is no state action, then the analysis stops. The threshold issues control everything that follows, right? And so I want you to notice this pattern here. For each issue, we do the same thing. We state the rule. We apply one or two facts. We reach a conclusion. Even when the issue is easy, even when the answer feels obvious. This is what a high scoring bar answer looks like. It's not flashy, it's not rushed, it's deliberate, it's organized, and it's slightly more formal than feels necessary, right? That's intentional, you guys. The bar exam rewards disciplined analysis, not instincts, right? Easy issues are easy points, but only if you write them. Now we can get into our individual rights, which is which is where most of your points are going to come from. The First Amendment is not one right. I want to say that out loud, right? It's several distinct rights, each with its own analytical framework, right? So in our hypothetical, speech is very clearly the strongest claim, right? Establishment is significant. Free exercise is raised, but it's going to likely fail. And association and press, these are minor. But each right must be analyzed separately, right? Don't blend them all together. Don't put one big chunk that says freedom of speech / religion, right? Because they each have their own different analytical framework. And today, we're not going to cover so much the freedom of association. We're not going to cover so much the freedom of the press, right? Remember, you only bring them up if they apply. And in our hypothetical, they don't apply, but remember, they each have their own analytical framework. So on this slide, I want you to do one thing and one thing only. Recognize that there are 3 levels of scrutiny. Scrutiny is very, 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 very important, right? It's the framework that courts use to determine whether government action that burdens constitutional rights is constitutionally permissible, right? And these are not interchangeable levels, like labels. They are 3 distinct frameworks that the courts use. And we're going to go over these again and again and again because they come up in many places in constitutional law. So we're going to get them over with right out of the gate. We've got strict scrutiny. Now, strict scrutiny, this is the highest level of review, right? Strict scrutiny requires a compelling government interest and a law that is narrowly tailored to achieve that interest. Second, we have intermediate scrutiny, okay? This requires an important or substantial government interest and a law that is substantially related to achieving that interest. And then at the very, very bottom of the pile, right? We talk about negligence being the trash can. Well, if we're thinking of levels of scrutiny, rational basis, the minimum protection, that's your trash can. That's the lowest level of scrutiny. And it requires only a legitimate government interest and a rational relationship between the law and that interest. Now, at this stage, don't worry about outcomes. Don't worry about which side usually wins. Your job right now is to just simply recognize these three frameworks and what elements belong to each. Think of this as learning the vocabulary before you learn the grammar. Now, I really want you to hear these, so I'm going to say them one more time because this was a difficult thing for me to memorize, and it's something that a lot of students have difficulty on the bar. I highly suggest that you write this down on a piece of paper and you stick it somewhere you're going to look at forever and ever before you take the bar, because this is something you have to have memorized verbatim. Strict scrutiny is the highest level of scrutiny. It requires a compelling government interest and a law that is narrowly tailored to achieve that interest. Intermediate scrutiny requires an important or substantial government interest and a law that is substantially related to achieving that interest. Rational basis is the lowest level of scrutiny. It only requires a legitimate government interest and a rational relationship between the law and that interest. Write it down, draw pictures, because this is going to come up over and over again. So now that you can identify the three levels of scrutiny, let's talk about why scrutiny matters, because scrutiny is not just a label you attach to an issue. It is the framework that controls the entire analysis. Scrutiny tells the courts how skeptical it should be of the government's action. Once the level of scrutiny is chosen, almost everything else in the analysis flows from that choice, which is why it is so important that we get the right level of scrutiny and why we're going to kind of beat scrutiny over the head a little bit here. Right? Identifying scrutiny immediately answers three foundational questions, right? Those three questions are: who has the burden of justification? What is the quality of the government's interest? And what's the required fit between the law and that interest? So let's talk about the first one, right? Who has the burden, right? We're talking about the burden of proof here, the burden of justification. Now, under strict scrutiny and intermediate scrutiny, the government bears the burden. That means that the government has to come forward with reasons, evidence, and explanations to justify its law, right? Under rational basis, you guys, the burden flips, right? Under rational basis, the challenger must prove that the law is irrational. This is allocation of the burden alone. This allocation of the burden alone often determines the outcome of the case, right? Because in our hypothetical, they are going to give us the facts that tell us why, right? If there are no facts to tell us why, right? Why to justify, then that kind of gives us a hint that it might be rational basis. However, if we're reading our hypothetical and it is thick of explanations from the government justifying why it's done what it's done, then the chances are pretty high it's going to be strict or intermediate scrutiny. Now, secondly, let's talk about the quality of the government's interest. Now, scrutiny tells us not just whether the government has an interest, but how strong that interest must be, right? A merely legitimate interest, it's just legitimate. That may be sufficient under rational basis, right? Because legitimate, rational basis, meh, right? But it will almost never satisfy strict scrutiny. Strict scrutiny demands a compelling interest, an interest of the highest constitutional importance. So, what could be super important to the Constitution? Protecting fundamental rights or national security, right? Those are constitutionally important things. So, without identifying scrutiny, you have no way to evaluate whether the government's interest is constitutionally sufficient. Now, third, this is the required fit between the law and the interest we just talked about, right? This is where scrutiny does most of its important work. So let's kind of slow it down a little bit here. So under strict scrutiny, the law must be narrowly tailored. That means that the government must show that the law is carefully designed to achieve its compelling interest without unnecessarily burdening constitutional rights. In practice, This often requires showing that there was no less restrictive alternative, no less restrictive means that could be used to achieve the same goal. And we'll unpack this concept in more detail later. Under intermediate scrutiny, the law must be substantially related to an important government interest. There must be a real evidence-based, oh no, there must be a real evidence-based connection between the means chosen and the goal pursued. However, the government does not need to prove that its law is the least restrictive means available. Okay? Under rational basis review, the law only needs to be rationally related to a legitimate interest, right? The court is highly deferential, right? The fit may be loose, it could be under inclusive, it might even be imperfect, and the court may even hypothesize reasons the legislator could have had for enacting that law. Now, we'll return to narrow tailoring, substantial relationship, and rational connection in greater depth when we start applying the concepts to speech and religion. But for now, I want you to understand that the phrases we're talking about, these phrases describe how demanding the court is being, not just different ways of saying, quote unquote, related, right? On the bar exam, you always explicitly identify the level of scrutiny before applying facts. Even if your intuition about the outcome is correct, skipping this step makes your analysis look unstructured, and that's going to cost you points. So think of scrutiny as choosing the rules of the game before you start playing. If your grader doesn't know which rules you're using, then nothing that follows appears controlled or deliberate, and it doesn't look like you know what you're doing. Now, this is the most important threshold question, right? In any First Amendment speech analysis. And it's always the first question you ask once you've established that speech, talkie, that speech is involved, right? The question is not whether the government is regulating speech. Often that part is pretty obvious, right? The real critical question is why is the government regulating the speech? Okay? So if the government is regulating speech because of what that speech says, or because of the message or the viewpoint that is being expressed, then that regulation is content-based. Content-based regulations are presumptively unconstitutional, and they are subject to strict scrutiny. A regulation is content-based if you must look at the content of the speech to determine whether the law applies. Now, if enforcement requires reading a sign, listening to a message, or hearing a viewpoint, then that's a strong signal that the regulation is going to be content-based. Content-based regulations are viewed with extreme skepticism, you guys, because they allow the government to favor some ideas over others, right? And the First Amendment is designed to prevent the government from acting as an arbiter of acceptable ideas, opinions, or beliefs, right? You should be free to have crazy beliefs. By contrast, if the regulation does not depend on what speech says, but instead it regulates when, where, or how the speech occurs, then the regulation is content neutral. Content neutral regulations are typically called time, place, and manner restrictions, and those are subject to intermediate scrutiny. The idea is this: content neutral regulations regulate the incident of speech, not the ideas, right? They apply regardless of the message. So, for example, a rule limiting amplified sound after 10 p.m. applies whether you're given a political speech, playing music, or protesting. The government's concern here is noise, not what you're saying. It's not your ideas, right? It's the noise. Then we have viewpoint discrimination. And that is the most egregious form of content-based regulation. Viewpoint discrimination occurs when the government allows speech on a topic, but it prohibits speech expressing a particular perspective on that topic. This is almost always unconstitutional because it represents an attempt by the government to suppress disfavored ideas, right? On the bar exam, you should always explicitly state whether the regulation is content-based or content neutral, and then explain why. This classification is going to determine, you guys, what? Our level of scrutiny. And what do we say once we determine our level of scrutiny? This often determines the outcome of the case, right? So if you skip this step and jump right into scrutiny without explaining the basis for the classification, then your analysis is going to look conclusory and you're going to lose points. So a simple way to spot content-based regulations is to ask yourself, am I reading or listening to the speech to know whether this law applies? If your answer is yes, then the regulation is likely content-based. But if your answer is no, and the rule applies regardless of his message, right? Then that is more likely going to be content neutral, right? The reason this distinction matters so much is that content-based regulations pose the greatest risk of free expression. Once the government's allowed to regulate ideas, even for like seemingly benign reasons, then the door's open to censorship, right? Now, content neutral regulations, by contrast, they're tolerated, right? Because they allow the government to manage public spaces and competing uses without favoring or suppressing particular viewpoints. So when we're talking about content neutral regulations, right, we're talking time, place, and manner. Now, where speech occurs matters a whole lot in First Amendment, right? Because the Constitution doesn't treat all government-controlled property the same. So the First Amendment does not give individuals, the right to speak anywhere they want, wherever they want, right? Instead, courts balance the speaker's rights, like what are my rights, against the government's ability to manage its property. And that balance depends on the type of forum, okay? Courts divide government controlled property into different categories, right? They not just government controlled properties, but all properties, right? And so we've got the traditional public forum, the designated public forum, and the non-public forum. All right. So let's talk about this. The traditional public forum, this is things like streets and sidewalks. These are the traditional types of public forums, right? And these types of public forums receive the highest level of First Amendment protections, right? These are places that by long historical tradition have been open to the public for expression, right? Have been open for assembly, have been open for debate. And you want to think about things like sidewalks, parks, public streets, places where political speech has always occurred. Like in the town I live in, every protest that they've had here for like the last 10 years has been in front of our museum. So that historically makes the sidewalk in front of the museum a traditional public forum, right? The key point is that the default in a traditional public forum is to protect that, not to restrict that, okay? But now let's talk about non-public and private forums, right? Because by contrast, private property, right, and non-public forums, they have like less First Amendment protections, right? Because a non-public forum is government-controlled property that is not traditionally open to public expression. And these are like office bases, military bases, right, or certain school facilities. Right? The government doesn't want you protesting on a military base. Why? Because it's secret, right? Because we have government secrets there. We don't want just people storming around doing all kinds of crazy things. That's a protected area, and it should be, right? In these types of spaces, the government has greater authority to restrict speech in order to preserve the property's intended use. Regulations in non-public forums need to be reasonable. That's all they need to be. They only need to be reasonable and viewpoint neutral. However, and this is critical, you guys, even in non-public forums, viewpoint discrimination is still forbidden. So the government may limit access, they can control the subject matter or restrict speech to certain uses, but it may not suppress speech because it disagrees with whatever that speaker is saying. right? And why does this matter so much? Well, this matters a lot in our hypothetical, right? Because in our hypo, we're told the teacher is protesting in front of a school. And that phrase matters a whole heck of a lot. If the teacher's standing on a public sidewalk, then she is speaking in a traditional public forum. Her speech, which is a peaceful political protest, that's going to receive the highest level of First Amendment protection. Any attempt to stop her speech, especially through an injunction, that would face strict scrutiny or it'd be treated as a prior restraint. If, however, on the other hand, the teacher is standing on the school property, right? Like she's on a private walkway, or if she's standing in a courtyard owned by the school, then the analysis would change dramatically, right? Because the school may have greater authority to restrict access, particularly if the property is private, right? This is why forum analysis is not a technicality, right? It often is going to determine the outcome of that First Amendment claim entirely. Now, on the bar exam, you should always do three things when forum issues are present. First, identify the location precisely using the facts given. We were told in our hypothetical public sidewalk. So use public sidewalk, right? Second, classify the forum. Is this a traditional public forum, a non-public forum, or a private forum? This is, or a designated public forum, right? This is very clearly going to be our straightforward traditional public forum, right? Because it is a sidewalk. Now, because the speech, and we would say, we could say something like this, because the speech occurs on a public sidewalk, a traditional public forum, the government's ability to restrict speech is severely limited. Or you could say it a different way altogether. You could say if speech occurs on private or non-public property, the government may impose reasonable viewpoint neutral restrictions, right? But you have to go through that 1, 2, 3, right? Identify the location, classify the forum, and then state how that classification affects the level of protection and scrutiny. Now, one of the most important starting points in the First Amendment analysis is that speech, you guys, speech is presumptively protected, meaning there is a presumption. So we start every analysis with the presumption that speech is protected. However, it is a rebuttable presumption. If it wasn't rebuttable, we would not be here, right? So we start our analysis presuming, right? Because we're not assuming, you know what they say, assuming, right? We're not assuming, we are presuming here, right? And we're allowed to do that in the law. So we are presuming that this speech is going to be protected. However, right? There's a second piece to this, right? We start with the default. We start our analysis on the default that this speech is protected. The First Amendment is built on the assumption that free expression is the rule and that government restriction is the exception. So that means when we're reading about the government trying to regulate speech, courts should look at that with skepticism, not with deference, right? So this presumption matters because it immediately determines who must justify the regulation, right? When speech is presumptively protected, then the government bears the burden of explaining why it may restrict that speech. The person who's making the statement, that person does not have to prove that the speech deserves protection. The government must prove that restriction is constitutionally permissible. I hope you heard that difference. I'm going to say it one more time. The speaker does not have to prove that their speech deserves protection. The government must prove that restriction is constitutionally permissible. On the bar exam, students often reverse this burden and they don't even realize it. They jump straight into asking whether the speech is harmful, offensive, disruptive, or unpopular, right? And that's the wrong starting point. Don't be like, I know the rule, right? And then dive into unprotected speech because we start with the presumption that all speech is protected unless otherwise proven in a court of law. And we're that court of law, guys. So we start our analysis with speech is protected, right? This is why before you analyze content, forum, scrutiny, Tailoring. You should always orient the grader by stating speech is presumptively protected by the First Amendment. That sentence tells the grader that you understand the baseline of the First Amendment, right? It signals that you know the government must justify its restriction, not the guy speaking. Only after stating this presumption do we then dive into asking the next three questions, right? Is that speech unprotected? Is that regulation content-based or content neutral? And then what level of a scrutiny applies? Skipping the presumption makes your analysis look backwards. Including it makes the analysis look correct, right? Even if the rest of the discussion is really, really brief, make sure you state that presumption at the outset. You can also add this explanation, like you can also add, right? If you're writing in your essay and you have enough time, you can always say courts start with a presumption of protection because allowing the government to freely regulate expression poses a serious risk of censorship, even with well-intentioned restrictions, right? That can suppress unpopular or minority views. The presumption of protection ensures that the government must proceed cautiously and justify any restriction on expression, right? A very common mistake is to assume that speech loses protection because it's controversial, because it's upsetting, or because it's offensive. But that's not how the First Amendment works, right? In fact, controversial and offensive speech is often the speech that is most in need of constitutional protection. So remember, speech is presumptively protected by the First Amendment, and the government bears the burden of justifying these restrictions. Now, up to this point, we've established a baseline rule, right? That speech is presumptively protected by the First Amendment. So now we ask the next critical question. Does this speech fall into one of the narrow categories that the First Amendment does not protect, right? We start out with it's absolutely protected. But then we look to see, are we sure? Right? So this step isn't just about intuition or moral judgment, right? It's about classification. On the bar exam, your job is to identify whether the speech clearly fits within a defined, historically recognized category of unprotected speech. If it does not, then the speech remains protected, even if that speech is offensive, disruptive, or deeply unpopular. So think of unprotected speech as the exception, not the rule. Most speech, especially political or ideological or protest speech, that's protected speech. Unprotected speech exists only where the Supreme Court has determined that the speech's low value and high risk of harm justify allowing the government to regulate it without satisfying strict scrutiny. And courts interpret these categories narrowly, and so should you. So, the core unprotected categories of speech are incitement to imminent lawless action, obscenity under the Miller test, defamation, and then false commercial speech. Now, we learned about defamation, right? So we don't need to cover that one. And we've learned about false commercial speech. So let's go through incitement and obscenity, right? So incitement to imminent lawless action. Speech is unprotected if it's unprotected incitement speech only if it satisfies the Brandenburg test. This is the Brandenburg test. And under this test, speech loses protection only if it's directed to inciting or producing imminent lawless action and likely to produce such an action. This is a very demanding standard, right? Abstract advocacy, political rhetoric, or generalized call for resistance are not incitement. Right. So I want you guys, I'm not trying to make any political statements here, but I want you guys to think about what Donald Trump said on January 6th, where he said, we need to, what is it? We need to fight like hell and we need to go down to the Capitol and something, something, something. Right. Well, if you were given that specific phrase and you had to determine whether it was protected or unprotected speech, we would start with the presumption that it is protected speech. And then we would ask ourselves, it's clearly not defamation, it's not commercial speech, it wasn't obscenity. So is this incitement, right? And under the Brandenburg test, we ask, did that statement direct individuals to incite, or did it produce imminent lawless action? I think we can satisfy that prong. I think we can say that it causally, right, both actual and proximately, causally connected what he told people to do and then the imminent lawless action that occurred. However, there's a second ping or prong, right, to the Brandenburg test, and that says that it is likely to produce such action. Likely. And that is where everyone gets hung up. And that is why why it was this an incitement to violence, why we have never litigated this, and why this issue has yet to be litigated, because reasonable people can't get their heads together on the same page here, right? One person may say that is very clearly incitement. They're probably on one side of the aisle, and the other guy's going to say that's very clearly not, and they're on the other side, right? And so what he did was very much a gray zone, right? It's very much a gray zone. Now, let's talk about obscenity. And this is the Miller test. So, obscenity is only unprotected if you have all three prongs of the Miller test. All right. So, the first prong says that the average person, right, applying contemporary community standards would find the work appeals to the prurient interests. 2, the work depicts sexual conduct in a patently offensive way, right, as defined by state law. And then 3, the work taken as a whole lacks serious literary, artistic, political, or scientific value. Now, if any one prong fails, then the speech is protected. So this is crucial. Offensive or explicit speech is not automatically obscene. Obscenity is a legal term of art, not a moral judgment. So dropping F-bombs, calling people names, those are not, that's just offensive, right? If we want to say this is unprotected speech under the Miller test, this is unprotected because it's obscene, then we have to say that reasonable, prudent person in same or similar circumstances would see this as a prurient interest, that it was patently offensive under state law, and that it lacked any literary, artistic, political, or scientific value. And as you can see on the screen, right, mere nudity or sexual content is not obscene. So the obscenity test, I know a lot of us want to dive right into, that's the F-bomb, but it more often than not applies to pornography or to art that some individuals would call art and other people would call pornography. Now, I'm not going to cover defamation because we've all done defamation quite a few times, but I'll touch on commercial speech real quick. Remember, commercial speech proposing illegal transactions or that is inherently deceptive, that is unprotected, right? Most commercial speech, however, is still protected, and it's analyzed under intermediate scrutiny. So do not overuse this category unless the facts clearly involve advertising or commercial transactions. Now, apply this framework to our facts, right? The teachers' protest signs, they're criticizing the school's religious control over staff, right? And what is this? This is political and ideological speech, right? This speech doesn't urge imminent lawless action. It doesn't say go out and kill someone right now, right? It's not sexual or obscene. It doesn't assert false facts about an identifiable individual. It's not commercial speech, right? And because the speech does not fit within any narrowly defined category of unprotected speech, it remains presumptively fully protected by the First Amendment. Now, once speech is classified as protected, the government may restrict it only if it satisfies the applicable level of scrutiny. So that's when we get into correctly identifying that the speech is protected. That forces the analysis into scrutiny. And that, what do we say, determines the outcome, right? So remember, if you misclassify protected speech as unprotected on the bar exam, that is one of the best and fastest ways to lose points. Right. Another common bar mistake is arguing that speech is unprotected because it's offensive, disruptive, or because it causes somebody to be uncomfortable, right? This is not the test. If the speech does not clearly satisfy the elements of an unprotected category, meaning if it doesn't satisfy the Brandenburg test or the Miller test, right, then it's protected. So remember, because the speech does not fall within any narrowly defined category of unprotected speech, it is presumptively protected by the First Amendment, and any restriction must satisfy heightened scrutiny. Now we need to talk about prior restraint, because this doctrine shows up on the bar in subtle ways, and students often miss it, all right? So a prior restraint is a government action that restricts speech before it occurs, right? Rather than punishing speech after it's already been done. That's why it says prior. Prior means before, right? So this timing distinction is muy importante. It's very important because the First Amendment is far more suspicious of laws that stop speech before it's spoken than laws that impose consequences after it's happened, right? Courts do not like prior restraints because they pose the greatest risk to like the free expression of the people, right? When speech is stopped before it happens, then the public never gets to hear it. This is called chilling, right? It has a chilling effect. And that creates a serious danger of censorship, especially of unpopular or controversial ideas. And historically, prior restraints were used by governments to silence political dissidents, right? Religious criticism and oppositional viewpoints. And we're America, so we have the First Amendment, and it was designed in a large part to prevent that kind of suppression in advance. So, some classic examples of prior restraint, you guys, are court injunctions prohibiting future speech, right? Licensing schemes requiring government approval before speaking, orders from a court or from an administrative judge barring publication or protest before they happen. Of these, injunctions are the most frequently tested on the bar, especially in protest and demonstration cases. And guess what? Our hypo had an injunction in it too. So how do we identify a prior restraint in a hypothetical? Well, on the bar exam, the key question is very simple. You just ask yourself, is the government trying to stop speech before it happens? If the answer is yes, then you flag that as prior restraint, right? It does. It does not matter whether the government has a reasonable motive. It does not matter whether the speech might later turn out to be unprotected speech. The problem is the advance prohibition itself, right? Remember, injunctions preventing future speech are a classic prior restraint. So when a court orders a speaker not to protest, not to publish something, or not to speak in advance, it is imposing a prior restraint, even if the injunction is content neutral and well intentioned. Because injunctions operate prospectively, they trigger the most demanding First Amendment review. Now, prior restraints are presumptively unconstitutional. That means the government bears an extremely heavy burden to justify them. To uphold a prior restraint, courts typically require strict scrutiny and procedural safeguards, including prompt judicial review and narrow, definite standards, right? And in practice, very few prior restraints survive constitutional challenge. So when we're talking about our hypothetical, right, remember the school is considering seeking an injunction to stop the teacher from protesting. That request it's significant because it would prevent the teacher from speaking before she speaks. Even if the school claims concerns about disruptions or safety, right, whatever they're claiming, an injunction barring future protests would be treated as a prior restraint and would be presumptively unconstitutional. It has a chilling effect. This is why prior restraint doctrine is not just about speech, it's also kind of a remedies issue. And the type of relief sought can determine that constitutional outcome. And you'll learn more of that once you get in remedies. Now, a very common mistake is to analyze injunctions under ordinary time, place, and manner rules without recognizing that they are prior restraints. So if you see an injunction stopping future speech, you must always flag prior restraint first. If you do not do that, you will lose points. Now, let's talk about the overbreath doctrine. Now, the overbreath doctrine is a First Amendment doctrine that focuses on scope. The question overbreath asks is not whether the government may regulate some speech, often it can, right? But whether the law regulates too much protected speech in the process. So a law is unconstitutionally overbroad if it restricts substantially more protected speech than the Constitution allows, even if the law could be constitutionally applied in some circumstances. The overbreath doctrine exists to prevent the chilling effect on protected speech. Remember, we talked about that, just like prior restraints, right? We want to avoid the chilling effect, right? So when a law is written too broadly, people may refrain from speaking, not because their speech is illegal, but because they're unsure whether it might be swept up by that law. And the First Amendment is especially concerned with this kind of self-censorship, right? As a result, courts are willing to strike down laws that chill speech before enforcement even occurs. When a law is invalidated for overbreadth, it's often declared facially invalid, also called invalid on its face. Now, this means that the law is unconstitutional in all of its applications, not just as applied to the particular plaintiff before this court. This is unusual in constitutional law, you guys. Normally, courts prefer to invalidate laws only as applied to specific facts, right? But the First Amendment overbreadth doctrine is an exception to that rule. In most constitutional cases, a person may only challenge a law as it applies to them. Overbreadth is different. Under the First Amendment, the guy talking, a speaker, right? They may challenge a law on behalf of others whose speech may be chilled, even if the law could constitutionally be applied to the speaker. So this is a special standing exception designed to protect the marketplace of ideas. So how do we spot overbreadth on a bar exam, right? And usually you'll be able to see it when there's a law that regulates speech broadly or categorically, where the law is not limited to specific harmful conduct, where the law covers both protected and unprotected speech, or where the law lacks clear exceptions or narrowing language. So you want to ask yourself, does this law sweep in a substantial amount of protected speech along with any unprotected speech it targets? Right? If the answer is yes, then overbreadth should be flagged. So to analyze overbreadth, the courts ask whether the law's overbreadth is substantial in relation to its plainly legitimate sweep. Now, this isn't a numbers game, guys. It's a qualitative assessment. So the courts look at how much protected speech is affected and how serious the chilling effect is, right? If the overbreadth is substantial, then the law is what we call facially invalid and must be struck down. Overbreadth typically occurs after you've already identified that the speech is protected, right? We start with the presumption of protected speech, and then that the government is regulating speech. Once you've identified that the speech is protected and that the government is regulating speech, overbreadth is often raised in addition to content-based or time, place, and manner analyses, right? And importantly, a law can fail as overbroad even if it could survive scrutiny. So remember, when we taught you guys in first year not to write yourself out of essays, we're getting into the constitutional law where there's a lot of areas where you can do that. Don't do that. So let me give you a concrete example of what this means. So imagine a city enacts a law that prohibits all speech that disrupts the peace near schools, right? The peace near schools. The city could plausibly argue that it has a legitimate, even important interest in protecting students, right? And maintaining an orderly educational environment. And in some applications, the law might be constitutional. For example, the city could regulate shouting, amplified noise, or threats that actually interfere with school operations, right? However, the problem here is the scope of the law, right? All speech that disrupts the peace near schools. That's That's how it's written. The law could also prohibit peaceful protest as written, right? All speech that disrupts the peace near schools. And if there's sidewalks, then that's a traditional public forum, right? So that even though, right, as written, right, it could make sense, right, that it's protecting a important interest in, the student's safety, but as it's written, it could also prohibit peaceful protest, silent picketing, political leafleting, right? Or quiet demonstrations, all forms of which are protected speech. So even though the government could constitutionally regulate some disruptive conduct, that law, as written, and that law said all speech that disrupts the peace near schools, that law sweeps far more broadly than necessary. And it captures a substantial amount of different types of protected expression. And in that situation, the law may be struck down as constitutionally overbroad, even though it could survive constitutional scrutiny in certain narrow applications, right? And this is why overbreadth is so powerful as a First Amendment doctrine. The court is not asking whether the government can regulate any speech. The court is asking whether the law is written so broadly that it chills protected speech across the board. And when that happens, the law is facially invalid. Now let's juxtapose that with the vagueness doctrine, right? So the vagueness doctrine provides that a law is unconstitutionally vague, right, if it fails to give fair notice of what conduct is prohibited, or if it authorizes, encourages, aids, right, arbitrary and discriminatory enforcement. These these are the two constitutional problems that vagueness is designed to prevent: lack of fair notice and arbitrary enforcement. Right? A law must be written with sufficient clarity so that people of ordinary intelligence can understand if what they're doing is prohibited, right? If it's illegal. If reasonable people have to guess what the law means, or if reasonable people differ as to how that law applies, then the law is unconstitutionally vague, right? That reasonable person shows up all the time. And vagueness is particularly disfavored when we're talking about a law that regulates speech. When people can't tell what speech is prohibited, they may choose just to be quiet rather than risk getting thrown in jail, right? And this is self censorship. And we said that the Constitution tries to avoid self censorship. We do not want to chill speech. Right? The Constitution does not require speakers to guess whether their speech crosses an invisible or shifting line. Now, there's two parts of the vagueness rule, right? There's lack of fair notice, and then there's the arbitrary or discriminatory effect. Now, let's talk about lack of fair notice. So, a law lacks fair notice when it does not clearly define what conduct is prohibited. So, the question is whether a reasonable person who's reading this law could determine whether their speech in advance would be lawful. If people have to guess if what they're about to say is prohibited, right? Then the law fails the fair notice requirement. Now let's talk about arbitrary or discriminatory enforcement. So a law is also unconstitutionally vague if it gives excessive discretion to those who are enforcing it, right? So when a law lacks clear standards, police officers, prosecutors, right, judges, these are the guys that are left to decide on a case by case basis who to punish. And that invites selective enforcement, right? Including enforcement based on disagreement with the speaker's viewpoint, right? And what the Constitution tries to protect all of that. And that is why we have the vagueness, right? And I always remember it as void for vagueness doctrine. So on the bar, you should start to suspect vagueness when a law uses subjective or undefined terms. Think of words like annoying, offensive, disruptive, immoral, inappropriate. Those are subjective, undefined terms. And if you see that, bing, 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 I want you to start thinking immediately vagueness, right? You can spot vagueness when the hypo fails to specify objective standards for enforcement. or where it leaves speakers uncertain about whether their speech is allowed. So remember, ask yourself, would reasonable people have to guess about whether or not they were allowed to say that? If your answer is yes, then vagueness should be flagged. Now, once you identify, right, that level of scrutiny, the analysis immediately turns to two related questions. How strong is the government's interest, and how closely the law fits that interest? Now, these two questions, interest and fit, they're at the core of our constitutional analysis. Scrutiny is not abstract, right? It tells you exactly how demanding the court is going to be. So remember, not all government interests are equal, right? One of the most important things to understand is that the government interest exists on a hierarchy, right? Like we talk about formation, performance, breach, remedies, and we always start at the top. That's how government interests work. They work on a hierarchy. A compelling government interest is not the same as an important interest. And an important interest is not the same as a legitimate interest, right? These terms are not interchangeable. And using the wrong one on the bar, that signals that you don't know what you're talking about. Now, a legitimate interest is the lowest level, right? Almost anything the government does qualifies as a legitimate interest. Economic regulation, administrative efficiency, general public welfare. These are all legitimate interests. And this level applies under rational basis, right? Rational scrutiny. And that is a legitimate interest. An important interest, you guys, is more substantial, right? It reflects a real and significant governmental objective, like traffic safety, public education, or preventing discrimination. And this applies under intermediate scrutiny, right? This is mama bear, right? Legitimate is baby bear. An important interest, that's a mama bear. And then a compelling interest, that's papa bear. And that's the highest level, right? Compelling interest is an interest of the utmost importance, something essential, national security, protecting fundamental constitutional rights, preventing imminent harm, right? And this is strict scrutiny. Now, if you mislabel the interest, for example, you call something important when you're talking about strict scrutiny, you're going to get in trouble. You're going to lose points because strict scrutiny requires compelling, right? Compelling. It's a word game, and you have to memorize these words. So even if the government identifies the correct level of interest, that's not enough. The court must also examine how closely the law is connected to that interest. This is known as the fit between the means and the end, right? Different levels of scrutiny require different degrees of the fit. Under strict scrutiny, the law must be narrowly tailored to achieve the compelling interest. This means that the law must target the problem precisely, and it must not restrict more speech or conduct than necessary. Courts look really carefully at whether the government could have achieved this goal using less restrictive means, right? Alternatives that would burden protected rights to a lesser degree. If a lesser restrictive alternative exists and the government didn't use it, then the law fails strict scrutiny. This is why strict scrutiny is often described as strict in theory and fatal in fact. Now, that's Papa Bear, right? Let's talk about Mama Bear. Mama Bear's in the middle. She's intermediate scrutiny. This is substantially related. Under intermediate scrutiny, the law must be substantially related to an important government interest. This requires a real meaningful connection between the law and the objective, right? The law cannot rely on speculation, stereotypes, or, loose assumptions. However, unlike strict scrutiny, the government does not need to use the least restrictive means, right? The fit must be strong, but it doesn't need to be perfect. Now let's talk about baby bear. Let's talk about rational basis, rationally related, right? Under rational basis review, the law only needs to be rationally related to a legitimate government interest. This is a very different standard. The connection between the law and the interest, it can be loose, it can be under-inclusive, hell, it can even be over-inclusive, right? The court may even hypothesize reasons the legislator could have had. meaning they don't even know why the legislator did this. And it's important to know that under rational basis, remember, the challenger bears the burden of showing that the law is irrational. And with rational basis, right? You are not likely to win your case, right? Rational basis, if you're the guy bringing that one, you're losing. So remember, on the bar exam, once you identify scrutiny, you should always do the following in this order, right? First, always state the level of scrutiny. Second, identify the government's interest using the correct label, right? Is this legitimate, important, or compelling? And then third, analyze the fit. The fit, was it a narrowly tailored fit? Was it a substantially related fit or a rationally related fit? If you skip any of these steps, you are not going to get points for your entire analysis. So, with that foundation in place, right? Identifying state action, understanding all this stuff, right? Now let's get into the Establishment Clause. Now, the Establishment Clause of the First Amendment provides that Congress shall make no law respecting an establishment of religion. Through incorporation under the 14th Amendment, this limitation applies to state governments as well. Now, at its core, the Establishment Clause prohibits the government from endorsing, advancing, favoring, or becoming excessively involved with religion, right? Now, the clause is not hostile to religion. Rather, it requires the government to remain neutral, right? We don't want to promote religion and we don't want to inhibit religion. We don't want to get in your way of practicing. We don't want to stop you from practicing. We just want to be neutral. We don't want to encourage you and we don't want to discourage you. So the Establishment Clause issues arise under individual rights and specifically under freedom of religion. The threshold requirement is, of course, I hope you guys are all screaming at me, government action, right? The Establishment Clause regulates what the government does, not how private religious institutions operate. So once state action is established, right, such as funding programs, educational aid, regulatory involvement, whatever, once we've got state action, then the analysis turns to whether the government's conduct amounts to an unconstitutional endorsement or an entanglement with religion, right? We've got two things there. Is it an endorsement? Is it encouraging it? Or is it entangling with it, right? So let's talk about that. So historically, right, and when I sat for the bar, this was the test we used, the Supreme Court would do Establishment Clause challenges using what's called the Lemon test. And this is from the Lemon-Kurtzman case. Now, under the Lemon test, the government action is constitutional only if it satisfies three prongs. Prong one, the action must have a secular purpose. Prong two, the primary effect must neither advance nor inhibit religion. And then prong three, the action must not result in an excessive entanglement, right, between the government and religion. Think about commingling, right? Don't commingle, don't entangle, right? Failure of any of these prongs means that the government's action is unconstitutional. So the first prong is that secular purpose, right? That first question is whether the government action has a secular legislative purpose. A secular purpose, you guys, because I didn't know this when I first started doing this. A secular purpose is a non-religious objective, right? And that could be something like, we're not promoting religion, we're promoting education or public health or safety or welfare, right? And the government doesn't violate the Establishment Clause just because a religious institute benefits incidentally from a generally applicable program, right? Courts are generally deferential at this stage and will generally uphold a secular purpose unless the stated purpose is a sham or a pretext. The second prong, the primary effect, right? The second prong asks whether the primary effect of the government action is to advance or inhibit religion. And this asks, I have words, about the impact, not the intent. This asks about the impact. So the question is whether a reasonable observer would view the government action as endorsing the religion, right? Where aid is distributed neutrally and any benefit is incidental, then the primary effect is generally satisfied. And then the third is excessive entanglement. And that refers to ongoing, intrusive, or substantial interaction between government and religious institutions, right? The Establishment Clause does not prohibit all interaction between church and state. Some interaction is inevitable, right? You can't just avoid the church. The constitutional problem here, though, arises when the relationship becomes too close, too continuous, too supervisory, right? Now, courts consider factors such as whether the government must monitor how money is used, whether when we're talking about entanglement, right? Like how do we determine whether this is entanglement? Well, we look and ask whether the aid requires ongoing supervision, whether the program creates an administrative or political entanglement with religion, right? A one-time or a neutrally administered aid program, that is far less likely to result in excessive entanglement. Now, I did say, remember, when I went to school, we did the lemon test. However, more more recently in 2022, meaning that it is ripe for the bar these days, the Supreme Court has changed the lemon test. They've moved away from the rigid application of the lemon test. And in the Kennedy versus Bremerton School District, this is a 2022 case, the court made clear that the Establishment Clause analysis is now guided primarily by historical practices and understandings. I'm not kidding. So, under this modern approach, courts ask whether the government action is consistent with historical practices and understandings regarding the relationship between church and state. So, the central concern here is coercion. The Establishment Clause is violated when the government coerces individuals to participate, when it punishes religious dissent, and when it compels religious observance. Voluntary religious expression, even in public settings, is generally permissible absent coercion. So basically, we moved it from the lemon test, which was looking to make sure that there wasn't excessive entanglement, to what do we do historically? As long as you're not coercing nobody, then I guess you can have this nice speech of yours, right? Now, this shift does not mean that the lemon test has disappeared entirely, right? Lower courts and bar examiners still reference lemon concepts, particularly secular purpose, neutrality, and entanglement. However, the Supreme Court now emphasizes history, tradition, and the absence of coercion. For the bar, you should be able to articulate the lemon test, understand it, do an analysis on it, and then bring up the new test, which is historical with no coercion. So let's bring it all. Let's talk about the free exercise clause. And the free exercise clause says that Congress shall make no law prohibiting the free exercise of religion. Through incorporation under the 14th Amendment, this protection applies to the states as well. Now, the free exercise clause prohibits individuals from government action that burdens sincere beliefs or practices. And you know what? We don't question how sincere that is, right? So, what do? Step one is still state action. It will always be state action, right? So, as with all constitutional claims, the first question is whether the challenged conduct is fairly attributable to the government, right? Constitutional protections generally apply only to government action, not purely private conduct, right? And here in our hypothetical, the teacher is challenging her termination by a private religious school. That's generally not state action, right? Although St. John's receives secular instructional materials from the state, right? We said government funding or aid alone does not automatically convert a private actor into a government actor. And there's no indication that the state coerced, encouraged, promised, whatever, in the school's employment decisions. And so, as a result, a court would likely conclude that no state action exists, right? However, and this is muy importante, if you hear me now, right? It's very important. You should not end the analysis here, because even when state action is doubtful, strong answers continue by explaining how the claim would be analyzed, even if a court were to find state action. This is where we say, do not write yourself out of an essay. right? If this was your essay hypothetical and you just said, no state action, that's it, I'm done, then you would have written nothing but no state action, call one, no state action, call two, no state action, call three. And sometimes the bar does this because they want you to say, you know, if a court were to find state action, then the next step would be to determine whether the government's action burdens the free exercise of religion, right? So remember, this is a reminder, do not write yourself out of an essay. A substantial burden exists where the government pressures an individual to violate their religious beliefs or penalizes them for engaging in religious conduct. And here, our teacher's arguing that her termination burdens her religious beliefs because her living arrangement reflects her personal, moral, or religious conviction, right? Now, under Employment Division versus Smith, neutral laws of general applicability that incidentally burden religion do not violate the free exercise clause and they're viewed under the rational basis, right? Strict scrutiny applies only if the law targets a religion, only if the law is not neutral, only if it's not generally applicable. So if the termination were based on a neutral employment policy applied uniformly to all employees, then the free exercise claim would likely fail, right? Under rational basis review, because you always fail under rational basis. However, right, if the teacher could show that the policy selectively targeted religious conduct or it was enforced inconsistently, then strict scrutiny would apply. Right. And under strict scrutiny, the government would need to show that the action is necessary to achieve a compelling interest and that it's narrowly tailored to that interest. So, given the facts, it's unlikely that the government could meet that really, really high bar. Right. So, the likely outcome, right? The free exercise claim here is weak because the conduct is likely a private conduct, right? It's highly likely this is not a state actor. And because even if state action were found, the termination appears on neutral employment standards rather than targeting religious exercise. If we had given more facts that said, and they fired her and said, because you did, then we might have more facts. But currently, we just don't have enough facts. So now we're bringing everything together. We've just covered protected speech, forum analysis, scrutiny, prior restraint, overbreadth, vagueness, and we're going to apply it to the teacher's protest, right? So step one, we're going to identify the nature of the speech, right? The teacher's conduct consists of peaceful protest, criticizing the policies of a religious school. This is political and ideological expression, which lies at the very corner, the very core, not corner, the very core of the First Amendment protection, right? It doesn't fall within any category of unprotected speech, right? It is presumptively constitutional. It is not an incitement to violence. It's not obscene. It's not defamatory. It's not commercial speech. And accordingly, or it is highly likely, a court would conclude that the speech is fully protected by the First Amendment. Now, the next thing we're going to do is we're going to identify the forum, right? Next, we're going to consider where the speech is occurring, right? And we're told that the teacher is protesting in front of the school. If, as is likely, this refers to a public sidewalk, then that is a traditional public forum. In a traditional public forum, the government's ability to regulate speech is at its lowest, right? And any restriction must satisfy heightened scrutiny. Even if a court were to find that some portion of the area is non-public or privately owned, that determination would not automatically end the analysis. The court would still have to evaluate whether restrictions on speech are reasonable, viewpoint neutral, and constitutionally permissive. Then our third step would be to identify the type of restriction, right? The school's seeking an injunction to stop the teacher from protesting. Well, this is a big deal. This matters a lot because we know that an injunction would prohibit speech before it occurs rather than punishing speech after the fact, right? And we know that restrictions that prevent future speech are classified as prior restraints, and prior restraints are presumptively unconstitutional. Next, we would apply the appropriate level of scrutiny. And because the speech is protected speech, right? And because it occurs in a traditional public forum, and because an injunction would operate as a prior restraint, a court would apply strict scrutiny. Under strict scrutiny, the government must show a compelling government interest and that the restriction is narrowly tailored to achieve that interest using the least restrictive means. Right? General concerns about disruption, embarrassment, discomfort, those are unlikely to qualify as compelling interests, right? Specifically and particularly where the protest is peaceful. Then we move on to the next step, which is considering alternative doctrines, right? So even if the injunction were framed as content neutral, it would still face serious constitutional problems. As a prior restraint, it would require extraordinary justification, right? Extraordinary, because stopping speech before it happens, prior restraint, is presumptively unconstitutional. Additionally, any broadly worded order prohibiting protests could be challenged as overbroad, right? If it sweeps in substantially protected speech or vague, right? If it fails to clearly define what conduct is prohibited. Now, it's important, even if a court were to accept the school's argument that the protest creates disruption or safety concerns, the court would still need to ask whether least restrictive alternatives exist. So measures such as enforcing noise ordinances, time restrictions, or traffic regulations, that would likely burden speech less than an outright injunction. So the existence of these alternatives would further undermine the constitutionality of allowing for prior restraint. So once you've gone through your analysis, right, in light of the protected nature of the speech, the traditional public forum, the presumption against prior restraints, the demanding requirements of strict scrutiny, a court would likely conclude that an injunction prohibiting the teacher's peaceful protest is unconstitutional. And this makes the teacher's amendment, the First Amendment claim, the strongest claim in the case, not because of a label, but because it survives every stage of constitutional analysis. Now, the First Amendment protects the freedom of association, right? So we've got the freedom of association and the freedom of press. And we're going to go through these real briefly. I promise you we're nearing an end. I know this has been a very long class, but thank you for bearing with me. Let's get through these two and then we can wrap it up. So the First Amendment, we're talking about the freedom of association. This includes the right to join with others to advance political, social, or ideological goals, right? You're free to associate with who you want. You can politically associate, you can socially associate, right? And laws implicate freedom of association when they punish membership in a group, right? When they require you disclose that you're a member of a group, or where they penalize you for associating with individuals, right? Here in our situation, in the hypo we have, there was no such issue. The teacher wasn't being punished for belonging to an organization, and she wasn't being compelled to disclose any information, right? So although freedom of association is a recognized First Amendment right, it's not implicated here. So just remember, First Amendment freedom of association, that falls under this, as well as freedom of the press. Now, the First Amendment protects freedom of the press, which safeguards the right to publish information without undue government interference. Press claims typically arise where the government restricts publication. And so oftentimes when we're talking about this, we're talking about prior restraint, right? So anytime you're thinking about freedom of press, look for those injunctions, right? So imposing licensing requirements, or where we've got some kind of punishing for the dissemination of information. And we don't have any of these facts here, right? So let's just do a wrap up real quick. Let's step back. Let's look at the structure of what we just did, because this is where the bar points are got or lost, right? So we start first with, we did state action. Then we properly frame the threshold issues. Then we analyzed the protected speech. We classified the forum. We identified prior restraint. We applied the correct level of scrutiny. We addressed overbreath and vagueness. We conditionally analyzed the free exercise clause. We disposed of the non-implicated rights, right? And that took discipline. Those are good points. Good points. So remember, constitutional law, it rewards method, right? It rewards method. So even when the outcome seems obvious, you guys, these bar graders are looking for clear headings, full rule statements, proper sequencing, conditional analysis, right? Explicit issue disposal. And if you're skipping steps or if you're collapsing doctrines or if you're jumping to conclusions, you're gonna miss points. So remember, be relentlessly constitutional. Identify the right, state the rule, apply the facts, address alternatives, and then move on, right? Structure matters, discipline matters. That's how constitutional law is written. And that is how the bar is passed, you guys. So, with that, it has been fun covering this today. I look forward to speaking with you guys all in the next class.